I suffer from it every day of my life. I'm so messed up.
Were the of the individual?
Honestly, I don't remember me, period.
Have you not said you're sorry for taking my mommy away from me?
I don't know what to say. I'm sorry. I didn't mean for it to happen. I don't know.
Amanda Spurduty expressed remorse and apologized to the family and friends of the 3 individuals she killed in a tragic drunken driving accident. At just 21 years old, her blood alcohol level was found to be more than twice the legal limit at the time of the crash. Additionally, lab results revealed the presence of marijuana in her system on the night of the accident.
I suffer from it every day of my life. I'm so messed up. I suffer from this every single day of my life. I will for the rest of my life.
During the court proceedings, the families of the victims made it clear that they will never forget the tragic events that transpired. Walter Bedwell, who lost his 23-year-old son Scott in the crash, delivered an emotional testimony. Throughout his testimony, he never wavered in his gaze towards Amanda, the defendant.
You can still talk to your mother. You can cry with your mother. Eventually you'll laugh with your mother. I cannot. I want to hug my boy.
Sandra Rumbley tragically lost her 18-year-old granddaughter, Taylor McCaskill, in the crash.
My life has been changed forever.
Sandra Rumbley shared with the court that she'll never have grandchildren because of the accident.
And Lord, I know you can't possibly need Taylor as much as her mother and I did.
Sonia Hardy tragically lost her 18-year-old daughter, Sasha Hoffman, in the wreck.
We had the typical mother and daughter issues, and like all teenagers and their parents, we would quarrel over simple things, and I would give anything to argue with her again.
Spurduty, who had been tearful throughout all the testimonies, broke down after hearing Hardy's testimony.
He swear that the evidence you shall give to the court in the truth shall be inferred, shall be the truth, the whole truth, and nothing but the truth shall be done.
Amanda Spurduty has been sentenced to spend 7 to 12 years in state prison. The case of Lette Gonzalez took an unexpected turn due to a mistake made by Charge Officer Wagner during her arrest for driving under the influence. Wagner failed to administer a breathalyzer or blood alcohol test, but incorrectly marked that Gonzalez was over the legal limit of 0.08. As a result of this error, Gonzalez's driver's license was suspended, leading to her arrest 2 months later for driving on a suspended license. When the case came before Seminole County Judge Fred Schott, he expressed displeasure with the prosecuting team for attempting to punish Gonzalez without solid evidence. Schott emphasized that Gonzalez's license should not have been suspended without proof of her driving under the influence. He called for Officer Wagner to be charged with perjury, although the prosecution team declined to pursue this. In response to Gonzalez's injustice, Judge Schott ultimately dismissed the case. The exchange in court became heated, with the judge visibly frustrated by the situation.
Will you take him up for perjury?
He admitted it was a mistake, Your Honor.
No, but he lied. He lied on a sworn citation.
Your Honor.
Despite the jury finding Gonzalez guilty of driving under the influence, it's uncommon for a judge to overrule their decision. However, Judge Schott faced criticism for his outburst and perceived unprofessional behavior during the case. As a result, he was transferred from the criminal division to the civil division. Nvea Jackson is in court to testify against those responsible for ending her mother's life.
Have you not said you're sorry for taking my mommy away from me? My mommy was the love of my life. I remember that night and it scares me. You are supposed to love people, not hurt and kill them.
At just 3 years old, Nvea Jackson witnessed a devastating tragedy that would forever alter her life. On Christmas Day in 2010 in Los Angeles, her mother, Kashmir James, a 25-year-old nurse, was brutally murdered, shot 9 times by gang members who had mistaken her for someone else. Nvea was sitting in the back seat of the car during the attack. The unimaginable trauma she endured at such a tender age is heart-wrenching. 5 years later, Nvea, now 8, bravely stepped into a courtroom to testify against the alleged killers, marking an emotional moment in the trial.
I'll make you a present for Thanksgiving, I'll say. I'll make you a present for your birthday, I'll make you a present
for Halloween I'll make you a present.
Nvea Jackson's testimony in the trial of her mother's alleged killers, Darnell Deshaun Houston and Lamar McKnight, exemplified extraordinary bravery. Facing those responsible for her mother's death, Nvea not only sought justice for her mother, Kashmir James, but also aimed to prevent other families from enduring similar tragedies. The involvement of a juvenile in the crime led to a plea agreement. During the trial, an emotional Nvea posed agonizing questions to the gang members.
Have you not said you're sorry for taking my mommy away from me? My mommy was the love of my life. I remember that night and it scares me. You are supposed to love people, not hurt and them.
For Nvea Jackson's grandmother, Kim Evans, who lost her daughter, the trial is just another painful step in her ongoing grief. It's hard to grasp what Nvea and her family have gone through. Despite this, Nvea's strength shows the power of the human spirit. She saw the worst of humanity at a very young age, but is determined to help fix it. She's now involved with a foundation named after her mother, which works to fight gang violence and improve safety in South Los Angeles. In 2014, 3 lives were tragically cut short at Jewish sites in Overland Park, Kansas, by Frasier. Video footage from the area implicated Frasier in the heinous act, encouraging law enforcement to charge him with the crime. While every suspect may seek an opportunity to confess to their misdeeds, their actions will always carry more weight than their words when weighed against their adversaries.
You know that what I did and what's in my heart is righteous, is honorable, is moral, and therefore, God, He will reward me. And that's what I believe, and that's what I'm going to, on my lips and on my mind, come hell or high water. That's my honest opinion. I've never lied to you, and I won't lie to you. The truth is so important. It's so real. I don't have to lie. My position is the truth, the whole truth, nothing but the truth, all the time. That's all you're going to get out of me. I never lied in this court one time. And I won't exaggerate it. Anyway, I'll stop now on this part and understand a few minutes. I'll be coming up there and showing you some videos and talking to you up closer.
The judge delivered a sentence that matched Frasier's actions.
I find from the review of the entirety of the evidence presented in this trial that the jury's verdict should be and is affirmed. And for your conviction for capital, you will be transported to the Kansas Department of Corrections to carry out the sentence as provided by Kansas law.
One day, my spirit will rise from my grave, and you all know that I was right.
Next, we go to the case of Sandra Twigs, a 59-year-old defendant who faces misdemeanor domestic battery charges related to her 18-year-old daughter. Twigs, who relies on a wheelchair and suffers from asthma, diabetes, and pulmonary disease, stands accused. However, as the case unfolds, it becomes apparent that Twigs' health issues were not sufficiently addressed, leading to tragic consequences.
Yes, ma'am. Good morning, ma'am. I've read the probable cause affidavit. Yes, ma'am. You don't have to respond to each thing, but thanks.
Initially, Judge Marilee Ehrlich engaged with Sandra Twigs in a friendly manner as she responded to the judge's statements. However, a shift in tone was imminent.
Priors, relevant priors, recent priors. Excuse me, ma'am, I'm asking my courtroom staff. That's okay. I'll let you know each time I'm talking to you.
Okay, I'm sorry.
That's correct, Jenna. No convictions.
No priors.
She rapidly grew agitated by the woman's responses.
Thank you. You okay, ma'am?
Yes, I am asking to see your people don't have a car.
Okay.
The judge observed the woman's discomfort but persisted in reviewing the case, noting some missing information.
Gets the fan. Okay.
Have an issue with the boyfriend of the daughter, and they.
How old is the daughter, counsel?
Miss Twigs, how old's the daughter? I believe 18.
She turned 18 on Monday.
Okay, she's an adult.
And Miss Twigs, the one before us this morning, filed a restraining order against the boyfriend, and I did verify that I do have the actual case number that was.
Excuse me. A temporary restraining order, civil, against her sister.
No, against the boyfriend of the daughter,
Okay.
which apparently the boyfriend.
Which at this juncture would become moot because she can't bring it any longer. It's the boyfriend. I don't know whose house this is. I don't know if she's in a position to evict. Excuse me, don't tell me.
Indeed, clear signs of the judge's agitation began to emerge.
And does your daughter live with you, ma'am?
Yes, ma'am.
Excuse me, don't say anything beyond what I am asking you. Trust me, I am ma'am. Ma'am. She lives with who?
She lives with me and she lives with my daughter in Miami.
Is that a different location?
Yes.
Excuse me. Oh, counsel, can you please, is there any way you can on the phone talk to these people?
The judge's frustration was mounting, and unfortunately, the poor woman didn't even have an opportunity to speak as she was interrupted before uttering a word.
Ma'am, my one question to you, can someone there give her water as a kindness? Ma'am, do you need water? Just nod your head.
And I'm breathing treatment.
Ma'am, I am not here to talk to you about your breathing treatment. Excuse me. Oh, Lord.
It was evident to anyone present that Twigs was not faring well, and the judge's behavior was only worsening the situation.
I'm not going to spend all day with her interrupting me. It's your turn to speak, counsel.
Miss Twigs, just stay silent for a moment.
Even he seemed to realize that her anger was escalating for no apparent reason.
Do you want her to stay in the home but have no harmful contact with you?
Absolutely, yes, ma'am. Yes, ma'am.
Excuse me. Excuse me.
This behavior is entirely unacceptable in a courtroom, particularly from a judge. Despite recognizing that Twigs wasn't feeling well, she failed to take the necessary steps to address the situation.
Instead of money, do you want to be supervised by pretrial release? Pretrial services. Ma'am, listen. Say it again. Do you have a microphone? You've already said too much. Listen, please.
She'll need to report to pretrial services before noon tomorrow. Then she has to check in by telephone twice per week.
Ma'am, listen to me. Listen. Don't even say yes. Just listen. Can you hear me? Do you understand me? I want you will get paperwork today before you're released from the jail. It will say that you have to check in with pretrial services by noon on Monday. You have to arrange for someone to carry you there if you can't get there yourself. And they will give you the further instructions about checking in. Do you understand me? Good.
Twigs was released without bond for the domestic violence charge, but she was required to check in with the court office after her release. The judge instructed her to arrange for assistance if she couldn't make it there alone. Tragically, a few days after her release, Twigs passed away in her sleep. Her goddaughter, Carolyn Porter, revealed that Twigs had attempted to explain how she was treated before her death. However, her anxiety made it challenging for her to articulate her experiences, leading to breathing difficulties. Following the incident, Broward Chief Administrative Judge Jack Tudor announced that Judge Ehrlich would not be returning to the courthouse. Ehrlich had already submitted her retirement paperwork a few weeks before the incident, and she was scheduled to retire in the summer. Expressing sadness and disappointment in Judge Ehrlich's behavior, Judge Judah stated that her actions could not be justified. He plans to apologize on behalf of the court to Twigs's family. Broward Public Defender Howard Finkelstein criticized Ehrlich's conduct as aggressive and tyrannical, emphasizing her lack of emotional fitness to remain on the bench. The incident revolved around William Green. In 2019, at Broward County Bond Court, a suspect punched a public defender. The assailant was later identified as 27-year-old William Green, who had previously been arrested on a battery charge, as per jail records. Following the incident, additional charges were filed against him. It's important for people to behave appropriately in court, but unfortunately, there are some who believe the rules don't apply to them.
He signed the arrest warrant. Secondly, I would note that the state has made a determination to file both charges as presented. Law enforcement has provided. As you can see, this arrest warrant was signed in December, so the state attorney's office has provided copies of the reports. I would also note, and I provided.
What happened? What happened?
What just happened?
He just punched the PD in
there. Who's attending to her?
Is Miss Chase okay?
Is there somebody? Jesus.
Judge, can we go on recess, please?
After the incident, Green appeared in court again, where he was ordered to be sent to a Baker Act facility. This is the case involving Sierra Day and Deonte Lewis, who stand accused of the killing of Sierra's daughter, Anya Day Garrett.
Ladies and gentlemen, have you reached a verdict in this case?
We have, Your Honor.
If you could give the verdict forms to my bailiff, please. Count one, aggravated. We, the jury in this case, being duly impaneled and sworn, do find the defendant Sierra Day guilty of aggravated in violation of Revised Code 2903.01C of the Ohio Revised Code, as charged in count one of the indictment, signed by all 12 jurors. Likewise, count two, guilty, signed by all 12 jurors. The further finding with respect to count two is guilty of felonious assault, permitting child abuse, endangering children as to the offense of violence under the murder B of count two, signed by all 12 jurors. Count three, guilty of felonious assault, signed by all 12 jurors. Count five, endangering children, guilty, signed by all 12 jurors. Further finding that the defendant did cause serious physical harm to Anya Day, signed by all 12 jurors. Count six, endangering children, guilty, signed by all 12 jurors. Further finding the defendant did cause serious physical harm to Anya Day, signed by all 12 jurors. Count eight, tampering with evidence, guilty, signed by all 12 jurors. Count seven as well, guilty of endangering children, signed by all 12 jurors. The further finding with respect to count seven, the defendant did cause serious psical harm to Anya Day, With respect to defendant Lewis, count 1, we, the jury in this case, being duly and panel sworn, do find the defendant Deonte Lewis guilty of aggravated in violation of 2903.01C of the Ohio Revised Code. Count 2, murder B. Defendant is guilty, signed by all 12 jurors. With respect to the further finding of the offense of violence, he was guilty of felonious assault, signed by all 12 jurors. The further finding of permitting child abuse was guilty, signed by all 12 jurors. And endangering children is guilty, signed by all 12 jurors. Count 3, the defendant is found guilty of felonious assault, signed by all 12 jurors. Count 4, permitting child abuse, found guilty, signed by all 12 jurors. Count 5, endangering children, found guilty by all 12 jurors. Further finding, he did cause serious physical harm under the further finding of endangering children. Count 6, guilty, signed by all 12 jurors. The further finding was in the affirmative, signed by all 12 jurors. Count 7, endangering children, found guilty, signed by all 12 jurors. The further finding was in the affirmative. He did cause serious physical harm, signed by all 12 jurors. Finally, count 8, tampering with evidence, found guilty by all 12 jurors.
Jurors delivered guilty verdicts for Sierra Day and Deonte Lewis on charges including aggravated murder, felonious assault, permitting child abuse, 3 counts of endangering children, and tampering with evidence. Sierra Day, age 24, was sentenced to life in prison without the possibility of parole. Her boyfriend, Deonte Lewis, age 27, received a life sentence with the chance of parole after 20 years. Mark Sievers, aged 54, was found guilty of conspiring to have his wife, Teresa Sievers, a 46-year-old doctor from Southwest Florida, murdered over 7 years ago.
We'll ask our foreperson again, have you reached a verdict? If you'll please pass the verdict form to the bailiff. We'll let the clerk publish the verdict.
In the Circuit Court of the 20th Judicial Circuit in and for Lee County, Florida, criminal action. State of Florida versus Mark D. Sievers, case number 15 CF 673B. Verdict form, penalty phase. We, the jury, find as follows as to Mark Sievers in this case. A. Aggravating factors as to count 1. We, the jury, unanimously find the state has established beyond a reasonable doubt the existence of the capital murder was committed for pecuniary gain. No. We, the jury, unanimously find that the state has established beyond a reasonable doubt the existence of the capital felony was a homicide and was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes. If you answer yes to at least one of the aggravating factors listed, please proceed to Section B. If you answered no to every aggravating factor listed, do not proceed to Section B. Mark Sievers is not eligible for the death sentence and will be sentenced to life in prison without the possibility of parole. B. Sufficiency of the aggravating factors as to count 1. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt in Section A, we, the jury, unanimously find the aggravating factors are sufficient to warrant a possible sentence of yes. If you answer yes to Section B, please proceed to Section C. If you answer no to Section B, do not proceed to Section C. Mark Sievers will be sentenced to life in prison without the possibility of parole. C. Mitigating circumstances. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. No. Please proceed to Section D, regardless of your findings in Section C. D, eligibility for the death penalty for count 1. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt in Section A outweigh the mitigating circumstances established in Section C above as to count 1. Yes. If you answered yes to Section D, please proceed to Section E. If you answered no to Section D, do not proceed. Mark Sievers will be sentenced to life in prison without the possibility of parole. E, jury verdict as to death penalty. Having unanimously found that at least one aggravating factor has been established beyond a reasonable doubt in Section A, that the aggravating factor or factors are sufficient to warrant a sentence of death in Section B, and the aggravating factor or factors outweigh the mitigating circumstances in Section D, we, the jury, unanimously find that Mark Sievers should be sentenced to death. Yes. If your vote to impose death is less than unanimous, the trial court shall impose a sentence of life without the possibility of parole. Dated this 10th day of December in Lee County, Florida.
Either side like the jury polled?
Yes, please.
One moment. I'll start with you, our four-person, your juror ID or number or your initials, please. Is that verdict, ma'am, that do you agree that at least, excuse me for a minute, do you agree that each of the findings in the verdict form is yours? Sir, your name or initials or ID number? Each of the findings in the verdict form is yours.
Yes, I do.
Ma'am, your name, initials, or ID number? Do you agree that each of the findings in the verdict form is yours?
Yes, sir.
Ma'am, your name or ID number or initials? Do you agree that each of the findings in the verdict form is yours? Ma'am, your name, ID number, or initials? Ma'am, do you agree that each of the findings in the verdict form is yours?
Yes.
Ma'am, your name, initials, or ID number? Ma'am, do you agree that each of the findings of the verdict form is yours?
Yes.
Ma'am, your name, initials, or ID number? Do you agree that each of the findings of the verdict form is yours? Ma'am, your name or ID number or initials? Do you agree that each of the findings of the verdict form is yours?
Yes.
Sir, your name, ID number, or initials? And sir, do you agree that each of the findings of the verdict form is yours?
Yes.
Sir, your name, ID number, or initials? And sir, do you agree that each of the findings in the verdict form is yours?
Yes.
Ma'am, your name, ID number, or initials? And ma'am, do you agree that each of the findings in the verdict form is yours? Ma'am, your name, ID number, or initials? Ma'am, do you agree that each of the findings in the verdict form is yours?
Yes.
Anything further with the jury from the state? From the defense?
No, sir.
Mark Sievers was found guilty of conspiring to hire two individuals to murder his wife. He was later sentenced to death. The incident revolved around Sydney Moorer. On December 17, 2013, in Carolina Forest, South Carolina, Heather Elvis was chatting lively with her friend after meeting up with her boyfriend. But then, Heather disappeared without a trace. After an extensive investigation, the police arrested Sydney Moorer and his wife, Tammy Moorer, for kidnapping Elvis. Sometimes, the person we suspect the least might have accomplices, or those we assume are accomplices, could actually be the main culprits. Each case needs to be carefully examined by the court.
Middle of 2013, this young lady meets that defendant. They work together at the Tilted Kilt, a restaurant in Myrtle Beach. She's a hostess. He's a night maintenance man. They meet and an affair develops. It develops passionately. It's a romantic affair. And I say affair in the truest sense of the word because he's married to his co-defendant, Tammy Moore. Obviously, she doesn't know about this affair. It develops and he begins to bring her things to work. even when he's not working. Brings her things like coffee and donuts and bagels. He courts her, for lack of a better term. This goes on for quite some time, and they communicate extensively. When they're not in person, they communicate like every young girl communicates with everybody in the world via telephone. She uses her cell phone for everything. She texts him, she calls him, he texts her, he calls her. And we're going to show you that. We can show you visibly because it's a phone record that was not in their custody or control, and they couldn't alter, delete, or destroy it. That's something we can show you. Simultaneously, we're going to show you where Sidney, from his phone, was talking with his wife. And rightfully so. He's married to her. Just as extensively. He's talking to her, she's talking to him from her phone. So we're going to show you the communication between Heather and Sidney and Tammy. It's constant communication, ladies and gentlemen, and you're going to see it. And it's not out of the ordinary for somebody leading a double life, I guess, having an affair and being married. It's constant communication that doesn't stop, and then it does. It stops abruptly. And it stops abruptly for one reason. Because that man's wife finds out about her. She reaches out to her. We're going to show you that from her phone. And that causes all communication to stop. One reason. The boss lady lays down the law. And Sidney gets put on probation. He submits completely. What does that mean? There are conditions now. She doesn't leave him, but he don't get a phone anymore. She takes his phone. We'll present evidence to show you that. He can't work at the Tilted Kilt anymore. He can work at his other jobs, the other restaurants he works at night, but not the Tilted Kilt, because she works there. She ain't having it. Even when he can work at his other jobs, ladies and gentlemen, she ain't leaving his side. They're stuck at the hip. He is not going anywhere without her, and she's got his phone and hers. There are other conditions. This sounds like I'm making it up or exaggerating, but I'm not, and we'll present evidence to this effect. Another condition, ladies and gentlemen, is that at night, when he lays down in the bed, he's handcuffed to the bed. I'm not exaggerating, literally handcuffed to the bed. She does not trust him enough to get up and pee in the middle of the night. Another condition, he gets branded. Gets Tammy tattooed across his lower abdomen. He's got it right now. We'll present evidence to show you that. So he's on probation. And Heather is done. She's caught. She knows she's made a mistake. She wants no part of it. She's terrified of his wife, and rightfully so. She wants no more part of it. She's done. The communication stops.
Love triangles can lead to serious consequences, especially when a husband or father is torn between his wife, child, and lover. The pressure to decide in such situations can be immense, and it may feel like no good options are available.
Miss Elvis said, "Hey, Sidney, I might be pregnant. I need to talk to you." There simply is no motive because nothing happens during this time period. What you'll see is that after his wife finds out about his affair, Sidney and his wife and his whole family go on this, I think it's about a 4-week kind of cross-country vacation. They go down to Florida, down through the Gulf, and over to Disney in California. And this will be verified by the GPS data that's in his truck. That's right, there'll be GPS data from his truck. And that's what's going on. This is a family that's not, if they're obsessed with anything, they're obsessed with redevoting themselves to their marriage. They're obsessed with how they're going to get the kids through school, how they're going to pay for health insurance. That's what the evidence is going to show about this time period. And on December 17th, the early morning hours of December 18th, when Miss Elvis goes missing, the next critical point is what happens from there to the end of December. You're going to hear that when she goes missing, Sidney voluntarily comes in, gives multiple statements. Didn't have to do that. His wife gives statements. And we'll see that he's pretty much instantly a suspect because of this affair, which again, he never denied. Nobody ever denied. Everybody knew about it. but the police develop a sort of tunnel vision early on. And so we'll see that by end of December, maybe early January, search warrants have been executed on his home, on his vehicle, the F-150 that we'll hear so much about. We'll hear that all these electronics in his house have been seized and searched by all kinds of experts. And so that doesn't turn up anything incriminating. So he's arrested in February of 2014, about 2 months later. So what is the smoking gun? What is uncovered that says, you know what, we need to close this investigation at this point because we got our guy? Do they uncover anything incriminating from his cell phone data?
Witnesses often possess information that the family may not be aware of. The victim's colleagues, friends, or neighbors might come forward with unexpected details that shed new light on the situation.
Okay, and to your knowledge, what was the relationship between the two of them?
It was a relationship.
Okay, and how do you know that?
She had her phone charging in the office and it was going off constantly while I was doing the scheduling. And I finally grabbed it to see who it was, thought maybe there was an emergency, and it was the defendant texting her.
Okay, and what were the text messages indicating?
Objection, Your
Honor.
Were those text messages from this defendant, Sidney Moore?
Objection, Your Honor.
Well, Your Honor, it's...
Under 602, she can establish how she knows it.
Oh, sure, Judge. How did you know the messages were from Sidney?
Usually, unless I had a finished ruling, because anything she discloses now, it'd have to be hearsay because she's reading from the text. Thank you.
The hearsay would be party of
I just ruled, Celeste, you lay your foundation if you want to.
Okay.
Thank you.
Miss Cook, when you were looking at her phone, who was texting her that you saw? Let me ask you something. When you had that phone, what were you doing with it? Just charging it?
Yes, I was charging it for her.
Okay, but she was always nearby, close to the phone.
Correct.
Okay. Now, let me ask you something. Tell me a little bit about, we've talked about how old Heather Elvis was. About how old was Sidney Moore at that time?
Honestly, I don't know. I guess upper 30s.
Okay. And did you know he was married?
I did.
Okay. Did you ever see his wife?
No.
Okay. So she never came to work with him while he was at Tilted Kill?
Not that I saw him.
Okay. And do you know if he had any kids?
Yes.
Okay. And how many kids did he have?
3.
Okay. Did you know where he lived?
No, I knew he lived in the area.
Okay. Now, let me ask you something. During the time this relationship was going on and he was bringing her coffee, he was bringing her bagels, coming to see him, even when he wasn't working, did at some point that relationship end?
It did.
Tell me about that.
It was mid to late October. I came into work and Heather was, she was very distraught, nervous. Found out later that 2 of the girls had played a prank phone call to work saying that it was Mrs. Moore and that she had found out that her and Sidney were having an affair. So she wanted to leave, we let her leave. After that, she said that there was no relationship and they had broken up.
And about when did that happen?
It was late October, early November.
And let me ask you something, was she afraid of Sidney's wife, Tammy?
Yes.
Okay. And let me ask you this. Tell me what, if any, changes you saw in her close in time to this breakup.
Objection, Your Honor.
What's the basis of the objection? What's the basis of the objection?
They were going into irrelevant testimony.
All right, ladies and gentlemen, when we have an objection, which was a matter of law for my consideration, that does not involve you, it's very appropriate for the attorneys to raise objections from time to time. There are 2 ways of dealing with the objection. One, we can have what's called a sidebar, which is out of your hearing, and it's intended to be that way, or we have to excuse you. We try to minimize the number of times you have to get up and leave, so that's what we will have at this moment. We still may have to do that, but we'll have a sidebar to approach. Objection is the relevancy, and I overrule and put it on the record in the first break.
Thank you, Judge.
Thank you, Judge. Ms. Cook, if you don't mind, tell this jury about the changes you saw in Heather close in time to that breakup.
Her physical changes, correct?
Yes.
I was in charge of the uniforms there, so it was 3 pieces. It was the bra, the shrug, and the skirt. She went from an A-cup bra to a B-cup bra, and then from a B-cup bra to a C-cup and a larger kilt. So she gained weight.
And let me ask you something. During that time frame, was she seeing any other man that you know of other than Sidney Moore?
Not that I was aware of.
And did you see any other man, visually, did you see any other man come up and see her at Tilted Kill?
No.
Okay. Now, while you were working at Tilted Kill, you were a full-time employee? Yes. So you were there about every day?
Yes.
To your knowledge, did you see her in a romantic or relationship with any other employee at Tilted Kill?
No.
Okay. Now, tell me a little bit, you've told me about her physical changes. Tell me, did you see anything mentally? How was her demeanor after this breakup?
After the breakup, she was sad. She eventually started coming back to her joking and laughing and normal self that we knew.
Okay. Now, when she started gaining weight, clearly, if you're having to reorder a uniform, this is a visible change. To your knowledge, did she ever take a pregnancy test?
Yes.
And how do you know that?
She did it at work while I was there.
And did you see the pregnancy test?
I did.
And what did it say? What was the reading?
It read error.
Okay. And did you know what that meant?
I didn't. I went and looked it up on the computer at work.
Okay. But you actually saw the test that she had taken?
Yes, ma'am.
Okay, so clearly this was a concern.
Correct.
How did she act when she brought you this test that said error?
She didn't know what it meant. She was trying to figure out, obviously, if she was pregnant or not, and she was very confused as to why it would say error.
Okay. Did she appear like she had taken a pregnancy test before?
Objection.
Stay.
Now, let me ask you this, Jessica. You said as time moved on, she began becoming her old self. Tell me how she was in December.
In December, she was her happy self. She was back, like I said, back to her joking around. She was at work, having fun with everybody. So she was back to Heather.
Now, let me ask you this. Did she ever lose the weight and go back to the old uniform?
No.
Okay, so even in December, even though she now was happy and bubbly, clearly the weight isn't going away.
Right.
She's continuing to gain the weight. Okay. Now, let me ask you this. Do you recognize Sidney Moore?
Yes.
Is he in the courtroom?
Yes.
Point him out to the jury. And is that the man that she was having an affair with?
Yes.
And during that time frame, was she having an affair with anybody else?
Not that I was aware of, no.
Okay.
In cases involving missing children, the punishment deserved by the abductor often brings more relief than anything else for the families. When facing the judge, the family typically seeks the maximum sentence for the criminal. However, the court imposes punishment based on principles.
I know it's within your power, I know it's within your judgment. And I know that it's been a strange journey between all of us. But you've always been honorable. And I defer to your judgment.
Ellis, thank you so much. And let me just tell you something, sir, as a father to a father. What you've had to endure, no person, no father should ever have to endure, no mother should, and certainly I can only speak for being a father. And I don't fault you for some of the things that have been said or felt. In fact, I understand them, and you don't fault yourself for that, sir. And my only wish for you and your family and all of your loved ones, and I know that, if I thought for a second that just telling you to walk out and satisfy what you're looking for, I would do it in a heartbeat. I really would, because I understand and I appreciate how magnanimous that statement that you just made is, that you're not looking to punish, you just want some closure for a lot of things. I just hope that somehow this will bring some peace to you, sir, and that you can start. You'll never, and you're right, it will never come back to what it was the day before she left. But I hope you can find some peace in your life and enjoy what's left, and that's what you're entitled to. So thank you very much. You bet.
I'm not going to appeal emotionally to you. I know you can't make your judgment and your sentence based on that. So I want to appeal to what we need and what you can justify legally. We need hope. And I just want to explain what I mean by that.
Sure.
All these years, we've been hanging on to the hope of what's hanging over his head, and what's hanging over his wife's head. The charges and the trials and the sentencing. The community, they waged war on the community because their only defense was to attack everyone else, and they retaliated. If he did that one right thing, just tell us where our daughter was, everything would have ended. The retaliation from the community would have ended. The charges would have been over. The torment for his family would have been over. All these things were hanging over his head, but all these things were that hope that we were hanging on to, that one right thing would have changed this up here. With this verdict and this trial, once you sentence, it's all over. But it's not over. Heather's still gone. There's nothing else holding over his head. So what I'm asking you is to give us something to work with. Don't just give him 30 years to run her like his wife got. There's not enough room to work with that. He's receiving false hope from a civil attorney that he's going to get rich and exonerated in a civil case. He has that hope, which I believe is why he didn't plead in this one. If he has 60 years, we have something to work with. We have something to go back on, and it's only a little window of time, a little window of hope, and it's all I feel we have left. So I'm asking you if you'll just give us as much as you possibly can to work with. He's not stopped his crime. He kidnapped, and you read the definition of the law. Until he releases her, she's kidnapped. And he hasn't given her back. He's still holding her hostage from us. So until he stops his crime, he's still committing it. There's no remorse. I'm just asking that you justify his sentence by the fact he won't stop. He won't admit what he's done. He won't take responsibility. He's still committing it to this day. Thank you.
Thank you, ma'am. Hi.
Morgan Elvis.
That's Miss Elvis.
It's funny. Most people know that I never am at a loss for words. In fact, I don't shut up.
That's okay. I've been accused of that too.
Yes. I know you've heard them talk about the ways that you think that it's impacted them, and this is meant to be a victim's impact statement. And I'd like to talk a little bit about what I've witnessed being taken away. Because it didn't stop at taking away Heather from our family. Because every day, I watch my dad turn into somebody that he is not. And I watch my brother hide away from the world. And I watch my mother turn into somebody that's just a shell of the person she used to be. And I can't witness my own transformation, but I am positive that it has been drastic. I'm not nearly the woman I was 5 years ago. And for better or for worse, I don't know. But I can tell you that our family is not the only victim. Our community has suffered and changed in ways that are unimaginable. And I don't know if you've noticed, but their family got up and left. Because they have been a victim in this as well.
Of course.
He has children that he disregarded and put them in line of fire when he made this action against our family. And I think that that's something we shall remember, that it wasn't just our family that is affected here, but his own. He couldn't even muster a thought for them. And I think that my dad's right. Even if we let him walk today, that would be fine, so long as we could have a funeral, have a coming home, have an answer so that you don't wake up in the morning and have the world crash down around you. It's not so much that it's not fair, it's just what's right and what's wrong.
Tears cannot erase a crime. Even when a criminal cries, people still see the crime, not the tears.
If I could give them closure, I would. I mean, anything I tell them to be a lie, there's nothing I can tell them to give them any closure. I understand, I have children, I get it. There's just nothing I can give them for closure.
Right. Well, thank you, sir.
And I know they suffered probably way more than I have, yes, and I feel bad for them, I really do. Nothing I can give them. I'm sorry that I can't.
Well, I'm confident of that as well. Thank you, sir. All right, anything else?
No, Your Honor.
Well, the one thing that I've said over and over, and I don't know that I appreciated it as much when I was a lawyer as I do now as a judge, is my heart goes out to the Elvis family and the extended families. There's just no words to describe what anything can be said to alleviate what you've suffered and will suffer. And I mentioned this early on that I saw the hurt my father with his father being tragically, how he had to deal with that his entire life. And he was, as I've said before, he was a bitter man and took his last breath at 81.
After carefully considering all the facts and conducting an independent investigation, the jury decided.
Let the record reflect Mr. Moore is present. Is the state ready to receive the verdict?
Yes, Your Honor.
Defendants ready to receive the verdict?
Yes.
Let's invite the jury to return.
Yes, sir.
Thank you.
Thank you, Judge. I've enjoyed it. Judge, can you ask me to approve the verdict?
Indictment number 2018 GS 263067, State of South Carolina, County of Horry versus Sidney St. Clair Moore. We, the jury, by unanimous consent, find the defendant, Sidney St. Clair Moore, on the charge of conspiracy to kidnap, guilty. Dated September 18th, 2019, signed by foreperson Wanda Sims. Ladies and gentlemen of the jury, if this is your verdict, so signify by raising your right hand. Thank you.
Now let the record reflect that each juror raised his or her right hand in response to the court's question. Or you may proceed in your position, counsel. Anything further from the jury, from the defendant?
No, sir.
Anything further from the state? Anything further from the defendant?
No, sir.
Thank you. Ladies and gentlemen, I'm going to ask that you go to your jury room for just a few moments. I'll be with you just a moment. Please, you may retire.
When delivering the sentence, the judge considers the needs of the victim's family, the criminal's family, and the severity of the crime. Then, the judge announces the appropriate punishment.
Common pleas deals with everything you've talked about, your loss, what you've experienced. That's what I was privileged to do. Some of my practice was representing persons that suffered damages and trying to get compensation for their damages. What I do in a sentence can never be construed as compensation for anything. It's not. And it should never be considered that way, because that's left for another branch of our court. And in this case, I understand your wish, and if I were standing there, I'd be saying the same thing. I really would. But in this case, Ms. Moore has been convicted and a concurrent sentence was imposed. And what I've heard in this case as evidence, and I don't have to conclude this, it's just a fact, that I think there was a conspiracy, was no question. There was a conspiracy. The dominant figure, we all can have opinions about that, but I think, my opinion is that she was a dominant figure in this action. Just from everything, and probably the most compelling one was the testimony of the gentleman that worked with Ford to me. And for that reason, I'm going to do this, so I'll let the Department of Corrections figure out what time he's entitled to.
Yes, sir.
I'm not going to make that call because he was punished for that, and he's serving the time to punish for the obstruction. If the department chooses to give you credit, so be it. I don't choose to do that in my sentence. But I will sentence him to 30 years on each one and run them concurrent. And I hope he'll continue to do something that he's doing. It doesn't surprise me. I know it was mentioned early on that I knew his mother and father, and I do. And I was privileged to know them. And the one thing I have come to know, the Bible speaks to this, I think it's Luke, who much is given, much is expected. And I'm paraphrasing. But I don't find fault with that. I know what he's given. I know the people. And that also is another reason for what I'm doing. Good luck to you, sir. Thank you, sir.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.